Now it's time to look at some developments out of the country. A court of appeal in Oslo, Norway, has dismissed the case brought against the government of Ghana by the private developers, some private developers there, over a breach of contracts. Now, in 2018, Ghana decided to establish an embassy in Norway. The acquisition of a chancery building, either by purchase or by lease, was deemed to be the official decision of the government of Ghana in terms of the establishment of that embassy. However, after the failure of authorities to approve the property for use as an embassy in Norway, Ghana actually pulled out of the deal, which resulted in that court case. The issue ended up in the Court of Appeal, which is now being ruled in our favor. So let's try and get some understanding to this. My colleague Richard Kojonyako is with the Joy News International desk, joins us with some updates and facts to this case. Richard, just give us the background to this. Tell us how, of course, all of this started and how we're ending up at the courts, where, of course, the concern is that would have to pay some amount of money. But then we also do know that the court disagrees with the company, because, mind you, in 2018, when we made that decision, there was a lot of controversy surrounding even the acquisition of the chancery itself. So on what basis is the court making this decision now, Richard?
Okay, so in 2018, Ghana decided to establish an embassy in Norway. And so the acquisition of a chancery building was very, very important to Ghana. A delegation from Ghana identified a number of properties, including the James Gate 3 at Frogner in Oslo, the property, the subject matter of the litigation. So on November 2018, Ghana received an offer from gov't to buy the property for 100 million Norwegian kroner. And this offer had a deadline of 7 days, and the 7 days expired by the November 29, 2018. You know, in contract, there is an offer and there is an acceptance. And so when you offer something, someone needs to accept. And on that last day, that is the November 29, 2018, Ghana's Charge d'Affaires, Regina Piasam, responded to gov's offer in these terms. And so these terms are very, very important in the judgment that occurred in Oslo. On behalf of the government of Ghana, Ministry of Foreign Affairs, we have the pleasure to accept the offer with the following condition. And so there were condition precedents in this case. And it is a condition of the acceptance of the offer and the final contract that the building is without significant defect, and that the renovation work is completed and performed in a satisfactory manner. And second, before takeover, there is a final approval without condition from relevant authorities for the use of the property as an embassy. And the third one was that agreement on a final contract of sale, we accept that the contract shall be based on the Sem and Johnson standard contract. And so subsequent to this certification by Ghana's appointed valuers, Ghana pulled out of the transaction on various grounds, including a failure on the part of the sellers to satisfy the condition of final approval from the relevant municipal authorities in Oslo for the use of the property as an embassy.
And Richard,
so
I guess... Right, and Richard, I guess it's on this point that the court is making that ruling. The fact that we're not able to convert the property
exactly. So,
into an embassy.
Exactly. And so there were 2 points that the court stood on. The first one, during the High Court decision, the court said that, well, it ought to have been ratified by Ghana's Minister for Foreign Affairs. And without that, they cannot do that. And you know, the choice of law and the jurisdiction, it was in Oslo. That was that. But the choice of law was in Ghana. And so Ghana had to, or the Minister for Foreign Affairs had to ratify the contract before the contract would be binding on Ghana. And so all of these things did not take place. And remember that there were clauses, and one of the clauses was not also satisfied. And based on that, the court threw the matter away. And so it was upheld. Ghana's case was upheld. And so the appeal was thrown away.
And I understand that there's an award in favor of Ghana as well. Do we know, in terms of monetary value, how much we're earning out of this case?
Well, so Oslo Court of Appeal dismissed the appellant's case in its entirety. It dismissed the appellant court case in its entirety, and Ghana would be awarded 1.5 million Norwegian kroner, and that is approximately 150,000 US dollars as compensation for procedural costs incurred before the Court of Appeal. And it further ordered Jones Brew to pay to Ghana 1 million Norwegian kroner, approximately 100,000 US dollars, for procedural costs incurred before the Oslo District Court.
Richard Kujinyako with our Joy News International Desk, giving us the latest on this. I want to bring in Dr. Ishmael Novo with the University of Education, Winnipeg. Thank you, Doc, for your time. I recall when this issue about the Oslo Chancery came up, ranking on the Foreign Affairs Committee, Samuel Okujeto raised some concerns about the propriety of acquiring this facility. Going forward, what lessons should we be picking from this, and how should that be guiding us as a nation? Doc, you'd have to first of all unmute so I can get the point you're making. Dr. Olonwe, if you can hear me, yes, I'm just asking you to, right, we can hear you, yeah, loud and clear now.
Okay. Good afternoon to you and your viewers, and it is very important that as a country we learn from some of these things. When the delegation returned, they should have actually run the properties, and also those who are offering them for sale, and looking at the background of all those people and knowing their capacity to deliver on the time that we want. The points or the letter that we gave out accepting the offer didn't give clear timelines as to when we needed the property. From the little I've read, there's no clear timeline as to when the property should be ready for us. So it gives the impression that we actually just accepted the offer because of a very short timeline that they have given without doing due diligence. So it means that we must be very clear on what we want and how we want it to be done. For this one, yes, we are happy that we have won, but maybe in another instance we will not be so happy. So the Ministry of Foreign Affairs have to streamline how they go about dealing with some of these foreign entities, and so that we know that, well, the entity we are dealing with is capable of delivering this project within the timeline that we needed. And when we are stating some of this agreement, we must be very clear on the time that we need the property to be ready.
But then, for now, we know that the case has moved in our favor, which means that, of course, due diligence was done, correct?
Yes, of course, you will say that because at least based on Ghanaian law, certain procedure that we followed to make the contract value was not followed. But then, as I'm saying, if you look at it, it would not be an issue in the first place if you had clear timelines. For instance, if I say on this day, if this is not done, then the contract becomes invalid. Then in that case, if they have not been able to do all those things within the stipulated time that should have been in the contract, then they themselves will have known that, well, we have violated the contract ourselves. So there's no need for them in the first place heading to court.
Is there any likely implication in terms of a possible diplomatic role between the Republic of Ghana and Norway? Some would say this is private business gone wrong, but are there some possibilities there in terms of just causing
actually no diplomatic intentions as a result of it, because this is the Ghanaian embassy, the state of Ghana, dealing with a private entity in Norway, and this judgment has been given by the Norwegian court. Indeed, so if anything at all, is just go to rather strengthen our relationship in the sense that we are ready to submit ourselves to institutions that they establish for justice. So it doesn't have any repercussions for Ghana-Norway relations. From my view, there's nothing to worry about.
And very finally, how often do we hear about these reports, and where do you suspect the challenge may be coming from?
I think that in the first place, there might be a break in communication between the people on the ground who are entering the agreement and the Minister for Foreign Affairs. There is clear clearly there is this lack of communication, because before you act, you have to take permission from the minister, who is the only person that has that authority, as it were, to enter this kind of agreement. So from what happened, it clearly shows that perhaps there is that break in communication where those on the ground were acting on their own and then communicating back as to what they were doing. But this is quite huge, because we are going to acquire property in the name of Ghana. That's why the Ghanaian laws clearly state what should be done. But when you look at it, it appears as if the Chade affair went about doing the business without actually the authority of the minister, because the authority of the minister is very crucial in entering this deal, which hopefully was not granted. That is one of the reasons why the court is throwing it out, because if you are running, embassies operate on the principle that while it's an embassy in another jurisdiction, they actually operate with the laws of the sending state, in this case, which is Ghana. So the sending state, that is Ghana, the laws of Ghana govern how we enter some of these international transactions. That is how come we are at the positive side of it. But I think that going forward, we must always streamline our communication so that the minister is always aware of what's going on. So that if you want to acquire the property, yes, a delegation is sent, 7 days period was given as to whether you accept or not. Yes, the minister have to make those decisions and communicate back to them. But this one looks like, yes, we rush into making the decision to get the property, and along the line, we realize that they are not able to deliver to our expectation. So that's why the issue of due diligence came in. How did we end up selecting that group and their property? Apart from selecting the property, did you also do some basic work on the group that is in charge of the property to be able to be sure that that group is capable of delivering to the quality and the standard that you want within the period that you want it? If that is not done, then you have a situation like this, where the group goes about doing what they think they could do, but at the end of the day, they were not able to give us what we wanted, and therefore we have to pull out of the deal. So if you had done a proper work on the group, their capacity to deliver, which other groups were they working with, all those kind of things, then you will know that, yes, they have the ability to get the approval and all those processes within the time that you want them. So if it appears that we didn't do any necessary background check on the group that offered the property, and therefore their capacity to deliver was not considered, and at the end of the day, they were not able to deliver. And of course, because as I said, from the point you gave, there are no timelines. So therefore, they assume that, well, we are on course to deliver what you wanted, and you pull out along the line. If you are giving them clear deadlines, then pulling out becomes much easier.
All right. Dr. Ishmael Lomo, we are grateful for your time here on The Pulse.